will now be joining us from Abuja to discuss the legal battle ahead as he seeks to defend his client against the weighty charges that have been preferred against him by the Nigerian state. Good morning, ifeanyi Ejiofor, and welcome to the morning show. Great pleasure to have you joining us this morning. Hello.
Good morning, Mr. Abati. It's a pleasure meeting. It's a pleasure being in your platform this morning. Thank you so much, Mr. Abati.
Thank you very much. Well, ifeanyi Ejiofor, you are counsel to Nnamdi kanu, and you'll be quoted in the papers saying that your client has been badly treated, not just by the Nigerian authorities, but also the Kenyan authorities involved in the entire saga. Although the government of Kenya has pleaded innocence in all of this, saying that they were not involved in any way whatsoever. What are the issues involved in terms of the procedure adopted by the Nigerian government and the extent of the involvement of the Kenyan authorities? If you may just present your case.
Thank you so much, Mr. Abati. Let's go straight to the point. Well, I have a number of issues I wanted to address in the course of this discourse. First of all, there was a clear collaboration between the Kenyan government and Nigerian government. I'm happy now that they are denying the fact that Nnamdi Kanu was arrested in their place and also handed over to Nigerian government. But I can assure you that by the time we finish with them at the international court, they will never remain the same. What's important at this stage, and I've already made known to the world, is that he was arrested at the airport on the 19th day of June 2021. And he was taken to an unknown residence. That is a fact. He wasn't taken to a custody, and they recognized the official custody of the police over there. He was taken to an unknown residence where he was subjected to inhuman treatment. Nnamdi Kanu was tortured, maltreated, and beaten, mercilessly beaten. So these are facts within our knowledge, confirmed by him to us. So after spending 8 days in their custody, illegal custody, they now beckoned on the Nigerian counterpart to come for him. And by the time they came, Nnamdi Kanu was apparently unconscious at the point they came to pick him. He was unconscious. He was near lifeless at the time they were back taking him to Nigeria. So, and consequently they brought him here. So now, to tell you the level of their conspiracy and the desperation to get him jailed at all costs by enemies. They brought him here on a Sunday, and the federal government is fully aware that I'm the lead counsel to Nnamdi Kanu. And there's a charge against him before the court, which has been subsisting has been going on. Because after invasion of his premises on the 14th of September 2017 by the Nigerian military and soldiers, who killed over 28 persons in his house, and by act of providence, he was narrowly escaped. We filed an application before the court for an inquest into what transpired in his house on the 17th of September 2017. For court to inquire as to what happened in his house, what led to his disappearance. And we are still in this process, because that is fundamental. This is a person that has expressed to the world that he's ready to come for his trial on October 14th, 2017. He wasn't planning to leave the country. He wasn't planning to run away from the trial. He was ready to come for the trial on October 14th. The matter was stated for commencement of trial. Then on September 17th, his house was invaded. So to tell you that the government was not ready at the time to prosecute him, because they have no evidence to establish even the charge preferred against him to even date. So they went after his life. Now it's compelling on the part of the court to inquire what happened to this person I granted bail. What led to his disappearance? Then surprisingly, on the 28th day of March 2019, when the matter came up for shorties to show cause why they will not be committed for contempt, why they were unable to produce Nnamdi Kanu. That was the proceedings of that day. The court gave an order revoking his bail. Then we said no, because the court should be bound by its records. We said no, and we filed an application to get that vacated. Since 2019 to date, the matter had severally come up before the court, the same court. And the court was not inclined to hear this application to vacate the order. And the worst thing is that the federal government has not filed any response to this application before the court. They have not filed a response in counter to application to get that order vacated. They were not interested. What they are interested is to how to get in Nnamdi Kanu at all means available to them. So now, he was brought into this country on Sunday after being detained, maltreated, subjected to all forms of inhuman treatment, and inflicted with severe injuries on account of handcuff that lasted on his hands for over 4 hours till before he was brought to court. And you can see him on handcuff in court on that day. Those injuries are still there. And a number of medical issues he's having today on account of what was the kind of treatment that was meted out to him. So they took him to court on a Tuesday. Labaran Chaibu Labaran, who is the counsel that was in court on that day representing federal government, is fully aware that barrister ifeanyi Ejiofor is the lead counsel in this matter. And I've been in court with him in all cases affecting Nnamdi Kanu and IPOB. He never extended the courtesy of informing me that that my client was arrested, was abducted, because in this case wasn't arrested. So, but when we get to that bridge, we'll cross it. He was abducted and kidnapped from Kenya and brought into this country. So now he didn't feel it confident, didn't see it confident or didn't appropriate to inform me that my client was arrested and has been brought to court on Tuesday. So that shows there's a collaboration between the government in question, as it stands today, and the people we are appearing before them. Because if after all there was any element of iota of transparency what they're doing, is compelling on the part of the AG, not the lawyer representing the Federation, to inform me that they are coming to court on Tuesday, so I can come to court and see my client. I don't know what happened, and this is quite from him what happened. So on Tuesday, they took him to court, and the court asked them, "Where is barrister Ejiofor? Is he not in court? Was he not informed?" They said no. They arrested him and brought him to Abuja on Sunday, and he's called today. So now there's an underlying fact that my client will not get fair trial in that court. That's settled. The issue of fair trial has been taken away by this collaboration. But we keep on watching. We are going to see them in court. So what happened as of today? I've seen him and he has given me every information and detail about what transpired in Kenya, how he was arrested, how he was taken to a non-destination, and how he was maltreated, how they nearly killed him over there. And it's obviously from what he told me that it was at the behest of the federal government that they were doing those things. So until when they beckon on them to come. These are against an obvious infraction to all international laws and treaties. So but at that level we're addressing it, we're going to address an international court at that level. So I'm letting you concern myself what's happening in the country. So it's obvious from every indication that my client will not get a fair trial in this court. Obvious. Until when the contrary is established. And now, Nnamdi Kanu was mandate in prison custody. Let me underline this fact. Long before he was granted bail, he spent over 2 years in custody before he was granted bail. The court itself is aware that he was in prison custody before he was granted bail. And at the point he was in prison custody, Nnamdi Kanu never at any point in time made any effort to leave the prison without the judicial process. Now, they remanded him in DSS custody, where they made it near impossible for his relatives which has to visit him, except on appointment by his lawyers. So that itself has also graduated to what I call mental torture. He's being subjected to mental torture as I speak to you now. Because when somebody is in incarceration, as a political prisoner, which is his, he has no access to his wife, he has no access to his brothers, he has no access to relatives to discuss with them and interact with them. Even lawyers who are coming to see him are coming on a specific approval by the DGSSS. So it shows that he is undergoing mental torture. And it is worse still when Nnamdi Kanu is under a debilitating health situation. He has a medical condition that needs to be addressed as quick as possible. Because it's only a living that can face trial. So this I can stop at this time to come up with a second question. Thank you.
Wow, that you've given us quite a lot to unpack. I want to start off with Kenya, because you've said you're going to address that in an international court. But Kenya's extradition laws make it quite clear the kind of offenses, the nature of offenses for which extradition can be granted. There's a list, and treasonable felony is not in that list. In fact, the law in Kenya, the extradition law, states that fugitives are not to be surrendered if the offense is of a political character. So you mentioned the charges proffered against your clients. Has the Nigerian government now expanded the range of charges levied against your client? That's my first question. What are the charges that Nnamdi Kanu is facing now? My second question, you've said that you don't feel that your client will get a fair trial in Nigeria, but he has been given access to you, his legal representative. What else would you need to see to convince you that a fair trial is possible, as is his right under Section 36 of the Nigerian Constitution?
Thank you so much. You will recall that on the day he was taken to court, that was last week Tuesday, Nnamdi Kanu was allowed to address the court because I was not in court. I was not in court. So that enough shows you that's the problem. Nnamdi Kanu is not a lawyer, and he has no competent to address the court. He might address the court, because if needful was done, I would have been in court to address the court, and also apply to the court that he should be remanded in prison custody. So that is a clear violation of his constitutional right to a fair trial. So because I was not in court, he was allowed to address the court. So that shows you that there is more to it than meet the eyes. Because they have, Labaran has my number. The office of AG has my number. They have simply put on a call across to me that they've abducted, whatever they call it, they classified it as my client somewhere in Kenya, and brought him to here. And I take him to court on Tuesday to continue to trial. Then I'll be in court on Tuesday. And also convince the court on the reason why he should be sent to prison, to correctional center. But in this case, the court allow him, which is abnormal, which is unethical, allow him to address the court. Why should court be asking him why he run away when I'm not there? We have an application before the court which contains his affidavit on oath, deposed before a commissioner for oath in Israel, stating the facts of what transpired in his house on September 14, 2017. How he nearly escaped death. How he was ready to come to court on 14th of October 2017 to face trial. Then this are before the court, and court never entertained it. Court never entertained it. These are record black and white before the court. Court has never entertained this application before the court. So I will be craving the court or at any adjournment for the court to hear it, because it's fundamental to his fair trial, to the right. The court will hear and understand what transpired in his house. That's very fundamental. Then the court is now allowed to address the court on these facts, which are already before the court. So that's area that's why I'm entertaining fear that he will be granted a fair trial in this court. So now, coming to what happened in court, the matter has now been adjourned to 26th of October, to 6th of July, 2021.
Ejiofor,
let me say this to you.
Ejiofor, sorry to interrupt you. We need to take a short break. When we take a short break, I see you are very passionate about this. So we're going to unpack all of those issues, and there will be more than enough time to do so. So we'll take this short break, and we'll come back to you. Please stay with us. Show here on the Arise News channel. Our guest is still Ifeanyi Ejiofor, counsel to the leader of the indigenous peoples of Biafra, Nnamdi Kanu. Well, Ifeanyi, yes, you said a lot, and we've listened to you, but we would like you to conclude your thoughts on what you were saying. But take this along with some of the things you wanted to say. First, you were accusing the Kenyan authorities that aren't we dealing here with the case of a fugitive from the law? A fugitive from the law who was also organizing against the Nigerian state along borders. I'm sure as counsel, you are familiar with what is called cross-border crime, transnational crime under public international law, and the role of Interpol in that regard. Second, the Court of Justice Binta Nyako, when your client was brought before the court, and then he was remanded in the custody of DSS. The court specifically, Justice Nyako that is, asked that you should be contacted, the counsel she'll be contacted. But you were saying no attempt was made to get across to you with a phone call. But I thought that the Court of Justice in Yako protected your interests by saying that going forward, when the Lordship announced the adjournment to July 26, talked about counsel for the defendant appearing in court. And you are talking about bail. You are talking about medical condition. Now, do you think that your client is in a safe place to ask, for further bail, given the fact that he became a fugitive from the law? The rationalization that you gave may not be tunable before the court.
Thank you, Mr. Bathy. I respect you so much. Let me just, it's important for us to correct an impression at this stage. My client is only a fugitive in the eyes of Nigerian law or court. So the prosecution of IPOB has never been endorsed by any country of the world, including any of African countries. So there's only a recognized or probably given credence by the Nigerian courts and laws. So let me address the first part. We have proceeding. We have what I call extradition proceedings. The fact that he was allegedly committed a problem or probably on a warrant to be arrested cannot stop the country from going into what they call extradition proceedings. Before it can be, his extradition can be granted by that country. And you have had it see that even the offenses he was being charged of at the time he was abducted from Kenya did not fall within the items specified under the Kenyan laws as those offenses that can be had under extradition proceedings. It's clear. So what we are saying is that it's subjective to Nigerian opinion. It's a law. It's a fugitive in Nigerian court. Why is it that no country of the world has endorsed IPOB as a terrorist organization? Because they are fully aware of my correspondence with them across the world that IPOB is a legal organization. IPOB is not it's a non-violent organization. And the order of the court obtained through the back door is being challenged before the Court of Appeal today. So they will allow the proceedings before the Court of Appeal to end because we filed our appeal against that order timelessly, challenging the prosecution of IPOB. Now, the federal government, it took them almost a year and 8 months to respond to all applications to file before the Court of Appeal. That notwithstanding, we still submitted to a delay. We never oppose the delay. And it's also when we have an application for stay of proceedings before the Court of Appeal. And also have an application to stop them from executing that order. So these are applications before the Court of Appeal. And they've been run away from the court. I can confirm that to you. I have documented this case file. They've been run away from the court. I'll tell you when they file their respondent brief. Even on the day they file a motion for them to enter appearance out of time, or for their brief to be accepted out of time, we file our reply to their brief on the same day in Court of Appeal, expecting the court to allow us to hear our appeal. And the court didn't hear it. The court didn't hear it. The panel constituted to hear our appeal, didn't hear it. About 10 o'clock, they send a message across to us that the court will not be sitting till date. So now, coming to the aspect of not informing me before he was taken to court, I'm not talking about what transpired in open court. I'm talking about the duty on the prosecution, on the part of the prosecution in this case, to call me when he was arrested and inform me, because he owed me that compelling obligation to inform me and tell me that the matter is called, my client has been arrested or abducted, whatever you call it. Then he'll be taken to court on Tuesday. Then I'll be in court to address the court on some issues. Not to my client allowed to be asked to address the court. So, and the court is fully aware that he was coming to court on that Tuesday. Because if you watch the proceedings that took place on that day, proceedings of the court, it never lasted for more than 10 minutes or 15 minutes. It never. He was just brought to court and informed the court, they transferred him to DS custody. The press were stopped from seeing him, from interviewing him. He was blindfolded. So tell me what offense has he committed? Even in the eyes of Nigerian law, Nnamdi Kanu is still presumed innocent today. He's still presumed innocent by virtue of Section 35(6) of the Constitution. So he's still presumed innocent today of all allegations against him. So he's being subjected, as we speak now, Of course, you know, a lot of things are going on. Both media trials. People are being paid to come and confess and say some things against Nnamdi Kanu. But I don't think I have any issue with that one. When we get to court, we'll address it. Media trials are ongoing. Somebody will come and tell the world that I'm an ESM member. I was admitted so that Nnamdi can't say this. It's an open court that we have to establish that thing. So we have to be circumspect on the media trial going on against Nnamdi Kanu because he has been arrested, he has been abducted and brought to Nigeria. So what my challenge and my concerns is stem from the fact that I was not informed that I was arrested. 1, 2, I was not informed that he was being taken to court on a Tuesday. So I believe the Rabalan Shaibu is under compelling you to tell me because we are sending correspondence and I have my number. I have no number.
If you can hear me real quickly. So what happens on the 26th? A lot of people are you're talking about bail now. You're talking about the fact that he's got medical condition, should get bail. But on the other side, on the side of the government, what they're saying is he's jumped bail before. So how will it be easy for you to be able to prove that case? That's